Well, good morning, everyone. And it is so nice to see people like face to face and not through a monitor. So thank you so much for being here this morning. And welcome to today's CLE. Someone can steal your house, and you've probably seen some promotions on TV about people stealing your house. And remote notarization is here. Ron and RIN, and I'm sure like many of you, who are these two brothers? And this is the way we're going. And so welcome to Westchester Hills Country Club. For those of you who are here live, and for those of you who are joining us online, welcome, welcome. I am Joe Petrillo. I'm president of All New York Title. And I have to do some housekeeping rules before we go further. So this is a CLE program. We're going to run from now until 10:15 with no break. It is a 1.5 credit program. And the method to obtain the CLE credit, for those of you here in person, you'll see on your table, use the attendance verification form found at your seat, and be sure to sign at the bottom and hand it to one of our people who will be at the table on your way out. For those of you who are online attendants, there will be attendance codes in the form of words, as you know, which will be announced at some point and will appear on the screen. Jot those down as they appear. About 10 minutes after the course ends, you will receive an email, and that email will contain a link on the attendance verification form to an evaluation form. Links to the forms will also be in the chat about 10 minutes after the class ends. And again, my suggestion is to keep a written record of the codes while the class is in progress so that you can refer to them when completing your form. You have to have, for those online, all the codes in order to get the 1.5 CLE credit. There is no partial credit. So, and we were delighted to be able to do a program like this that is for people who are live and people who are online. So we really look forward to your evaluation form because we value your feedback. Regarding questions are welcomed and encouraged. If time permits, we will take questions at the end, starting with our in-person guests. To better serve our online folks, questions on Zoom will be answered if we can during our program, but if not, after the program. One of either John or Frank or Tyler here will be able to reply. And with that, I wanted to thank Fidelity Title for joint sponsoring this event with us today. We're very appreciative to have Frank Carroll down here from Buffalo. He is a friend. He is one of my go-to counselors when we need some help. Frank is Regional Counsel for Fidelity National Family of Title Insurers, and he is the Senior Title Insurance Underwriter of New York, Connecticut for Chicago, for Fidelity, and for Commonwealth Land Title. He's a graduate of Lemoyne College, Syracuse, attended State University at New York at Buffalo School of Law. He's been admitted to the practice since 1981. He's worked in the title insurance industry since 1986. He is a member of the New York State Bar Association, the Bar Association of Erie County. He's past president of the Erie County Bar Foundation, and he's still actively involved in the affairs. He resides in Buffalo with his wife, Cornelia. Next, I'd like to introduce John Martin, Vice President, General Counsel at All New York Title. John has over 36 years legal experience in title insurance and real property matters. His responsibilities involve the legal operation of the company, from review of routine title issues to closing the most complex commercial transaction. John also handles operations for us of 1031 like-kind exchanges. He's chaired the law committee of the State Land Title Association, also served 10 years as chair of the Westchester County Bar Association Real Property Section. Prior to that, John held positions as claims counsel, New York, New Jersey State Counsel, president of operations for a major title insurer. John and I have been working together for over 37 years. We have co-owned All New York Title for 27 years. We started that when I was 12 and he was 10. And lastly, I'd like to introduce our youngest member to the team here. Tyler Gablenz is counsel at All New York Title. Since joining All New York in 2015, Tyler has focused his work on identifying and resolving title issues in the residential and commercial space. His responsibility includes reviewing reports, assisting clients, attorneys with clearing title issues, serving as escrow agent, and my right hand on a regular basis, unfortunately for him, for the last 5 years. Prior to joining All New York Title, Tyler gained experience in the real estate working for a firm in Connecticut while attending Quinnipiac University Law. Tyler earned his degree from University of Quinnipiac and was admitted to the State Bar in 2016. So we are looking forward to a good, lively program, and it's just so nice to see everyone. And gentlemen, I will leave it up to you now.
Thank you. So, thank you, Joe, for the introduction. My name is Tyler, as Joe introduced me. I'm going to start the program today beginning with the discussion on title theft. If you want to go to the next slide. We'll skip through some introductions here. Okay. So it's a little bit self-explanatory, but just as a brief introduction of what we're talking about in terms of title theft. You might be also have heard title fraud, deed theft, deed fraud, or some of the other terms that are being thrown around. It's a relatively new, somewhat new but growing method of fraud that's become a topic of discussion, and it's taking place on a somewhat more regular basis, and has become a point of discussion due to new companies popping up that are offering what they purport to be protection from this fraud taking place against you or your clients. So just a brief summary of what we typically see and how this typically works is a thief will draft a deed. You know, they can go on, as we know, the public records, pull a copy of a deed to a property. They will draft the deed to be the grantor would be the current owner, grantee would be themselves or some entity that they control, and then they would fraudulently execute the deed, fraudulently sign it as the current owner. And then, as we all know, you can submit either in person or electronically. Anybody can submit documents to one of our 62 county clerk city registers throughout the state. And as much as we would love for them to catch everything, they often don't. A lot of times they're looking more for proper drafting, execution of documents, submission type, and most importantly, payment of fees is what they usually look for. So it's not out of the question that a document fraudulently drafted and signed could get on the public records in the county where the property is located. What will then typically happen is one of two things. One that you see less common is the thief will then put the property up for sale and sell it to a bona fide purchaser with no knowledge that the person selling the property to them has committed fraud and taken the property from the rightful owner. We don't typically see that as often. The more common way that this is done is the thief, once they are the record title holder, will go to a lender, obviously again with no knowledge of the fraud taking place, and they will take out a loan on the equity of the property, and as soon as they get the check, oftentimes they are then gone, and the homeowner is left to clean up the mess. So a couple of things that you want to be aware of and take a look at, not just for yourself, but if your clients reach out to you with these particular issues that may be a tip-off of something like title theft happening. One would be that they are no longer receiving property tax bills, water bills, any notices from municipalities that they have been receiving. If those stop coming, that could be a tip-off that the records have been changed. If the tenants may receive a notice to send payments to another address, another recipient, this is another way that the thief can make off with gains from the fraud. If the homeowner, the rightful homeowner, receives notices or statements from an unfamiliar lender or bank, or a loan that they did not take part in. That would obviously be a tip-off that something has occurred. And finally, if it gets to this point, if you received any notice of an action, a foreclosure action, or other lawsuit related to a debt that the homeowner is unfamiliar with. And most commonly where we've been seeing this is, obviously, the thieves want to target the easiest and most beneficial properties for them to make the most gain from, which would oftentimes be homes that have high equity, maybe no mortgages or liens on it, vacant land, second homes, vacation homes, things that may go unnoticed for a longer period of time before the theft is detected. Okay, so then the reason why we are doing this presentation today is in response to this growing instance of title theft taking place. There have been companies, I'm sure you've all seen either online or on television, commercials and ads for these companies promoting protection against title theft. And there's a lot of misconceptions about what's actually being done here. The main point is that while they may, based on the title of the company or the way that it's promoted, it may seem like it is an insurance policy providing some monetary or actionable protection should this happen to a client or yourself. However, we found that you're not actually purchasing any sort of insurance policy. What these seem to be are merely monitoring services. They are essentially a service that combs the public records of the 62 county clerks for the subscriber's given property address or name. And in the event that a new document, in particular a deed or a mortgage, is recorded on the public records against the property, the subscriber to the service would be notified of that. And essentially, that's the extent of what the service is offering. And for that, you're paying, from what we've seen, anywhere from about $10 to $20 or more per month on a subscription basis. It's not a one-time fee. So your client or the homeowner is going to be continuing to pay a fee on an ongoing basis in order to maintain the monitoring service. And once they're made aware that an issue has been presented and that their deed has been stolen from them, their property has been stolen, the companies really don't offer any further assistance. They are not going to compensate them for monetary loss. They are not really going to step into the situation and assist with the actions to rectify the title, which oftentimes would require a court order to vacate the wrongful deed and possibly corrective documents being executed and recorded. So you're talking about a complicated process, a possibly costly process, and something that could take quite a bit of time. And frankly, the services are really not offering anything in that front. They're offering merely a monitoring service that, frankly, the county clerks are now, a lot of them are catching up to. And I've provided a list here in the materials, and you can see it up on the screen here. We now have the New York City Register, which covers Manhattan, New York County, Bronx County, Kings County, Queens, Suffolk County, Nassau, and Westchester on residential properties, 1 to 3, and condos. You can actually go on the county clerk's websites. Any homeowner could do this. Anybody can do this. On the websites, they offer for free the ability to plug in your name, property information, and provide an email address. And in the event a document, a deed or a mortgage is recorded in that particular land record against the property or your name, you'll be notified. The exact same service that's being provided by these new companies is being offered for free by a few of the county clerks that many of us in this room deal with on a regular basis and most regularly. I didn't get a chance to comb all 62 county clerks to see if this is being offered. Some have not caught up to this yet. But I expect in the near future that this is going to be an ongoing trend of county clerks picking this service up. Next slide, please. So now that we've given you the summary of the title monitoring services, you may be asking, what protection can we assist our clients with obtaining, or can I obtain myself? For that, there is the TOEPP owner's policy, which you can request anytime you order a title on a 1 to 4 family property when it's being purchased, and the insured is going to be a natural person or a living trust. Sue right in front of me here, she knows it very well. We've done it many a times. So this is an enhanced version of the standard owner's policy that you or your client would get at closing. And in this instance, what you're getting as the primary benefit of it is that, unlike a normal owner's policy, this includes post-policy date coverage, including coverage against fraud. So we're hitting right on the issue here. So if you take a look, you have the covered risks 1 through 6. These are covered in the policy under your standard owner's policy up to the date of. But in this case, you have item number 7, which covers any risks 1 through 6 occurring after the policy date. So in the event that someone were to, after the date of closing and after the date of the insured policy, were to fraudulently execute a deed, record it on the land records, and, for instance, take a mortgage out on the property and make away with the funds, you would be able to submit under the title policy covered risk number 3. Someone else claims to have a right affecting your title arising out of forgery, and you would be covered under the TOEPP policy. You do need to specifically have the TOEPP policy. Like I said, this is not a coverage contained in the standard owner's policy. And the additional benefit is, unlike with these title monitoring services, you are going to have the ability to recover, monetary losses possibly, but you also are going to primarily have the benefit of your title agent, your title underwriter who insured the policy, to pursue the actions necessary to rectify it. As I mentioned, it could be a complicated, lengthy process, a costly process, obtaining a court order, corrective documents being recorded, and you will have the expertise of the folks in your that you're working with in the title industry. In our office, somebody like Frank on the fidelity side, to assist with getting this cleaned up for your client. So just some further details on the TOEPP policy for those of you who are not familiar. I know a lot of you have joined us for seminars pre-COVID and years past, and we've done discussions on TOEPP in the past, not necessarily in the fraud context, but some details on this. So the TOEPP policy is, the premium for it is an additional 20% above the standard rate manual cost for an owner's policy. So it's a little bit extra cost, but it's a one-time cost up front. There's no ongoing subscription annual fee type situation, so it's a one-time fee. In addition to the post-policy fraud coverage and other post-policy coverages, you also have coverages for certain building and zoning items covered in risks 14 through 18. These are subject to some deductibles and maximum liability, which are all outlined in your materials and in the policy jacket. If you ever have any questions about that, we're happy to go through it and discuss it. And we've done many programs. I know Frank's done programs on the building and zoning aspects of TOEPP before, and if anybody has any questions on that after the fact, we'd be happy to discuss that. But importantly, going back to the fraud topic, the fraudulent deed or mortgage is not subject to the same deductible amounts or maximum liabilities. So there is some real valuable coverage related to covering the situation of fraud. And then the TOEPP policy also does include a built-in rider to increase the policy amount 10% per year for each of the first 5 years after the date of the policy. I think that's it for the title theft. And I think our first program code, I guess I'll give that as Notary. First program code is Notary. And I think I'll turn it over to Frank.
Well done.
Thank you.
think we're ahead. Jason, could you scroll back? Okay. Morning, everybody. Well, I was just asked to speak about this new thing in New York, remote notarization. And I first started hearing about this a number of years ago, and it just really seemed bizarre. And one of the things that disturbed me a bit, people are just throwing around these acronyms, and I just hate these acronyms. I think they're lazy ways of communicating. They're confusing. You know, in general, I see things in the press about POTUS and SCOTUS, and I think it's kind of demeaning to an institution to just use a little hand. You know, these are institutions, the President of the United States, Supreme Court. These were institutions that used to have some dignity, and now we've just kind of lowered them down to the level of just an acronym. And with RIN and RON, it says nothing about the behavior. What goes into this? What are we talking about? Well, it's a whole new ball game with remote online notarization. And what is it, remote notarization? Unlike the present, where we sit in front of somebody who is executing a document and taking that person's acknowledgement, now the notary is not in the presence of the person who's signing the documents. And there are various procedures and practices for doing this, which are recognized in many different states. There are probably about 25 or 30 states where there is some form of remote online notarization that's allowable. The thing that occurs to me, though, when I think about remote online notarization, I'm thinking about real estate documents. We deal with deeds and mortgages and SEMAs and discharges. And remote notarization has to do with a whole range of documents that we never see or care about in the course of our practice. Insurance claim forms, licenses of various kinds, you know, just simple statements relative to like auto accidents. And these might be 1 or 2 page documents. And, you know, granted, most of the time when we see deeds, they're a couple of pages long, maybe a little bit longer if there's a long attachment. But mortgages could be 35 or 40 pages. So there are, you know, certain obstacles that are that face us when we're dealing with documents of some length and some complexity. And that's really a concern of ours in the real estate and title business. So what was our first experience with RON in New York? When the pandemic hit and we all firmly believed that we would never be able to get together like we are today. Everything was always going to be remote. We would have situations where people didn't even want to leave their apartments to go down to the lobby of the building to sign a form. We had situations where a closer would go to somebody's house and slip the papers under the door and observe the person signing the documents through the window. Practices like that. And a lot of that was enabled by this executive order of Governor Cuomo that allowed remote notarization to occur in New York. Now, this was the first instance where there was some legal authorization for remote notarization. And the executive order said the whole thing, and it set forth various requirements on what had to be done in order to remotely notarize documents. There were no security concerns. There were no checks and balances. It was just simply authorization of certain procedures. So one of the things the executive order said that you have to get on some kind of a communication program or device. So people were using Zoom and FaceTime and GoToMeetings, and as long as the notary and the signer could communicate visibly, that was usually good enough. So what happened was, under the executive order, the provision is that the signer would sign a document, the notary would identify the document, and the signer would sign it, and then the signer was supposed to transmit this document somehow back to the notary, either electronically or by mail, and then the notary would confirm that, yeah, this was the document that I saw this person sign, and take the acknowledgement, and then supposed to send it back to the signer. This is what the executive order said. So how does the signer send this document to the notary? Well, you either fax it or scan it and transmit it to the notary, or mail. Well, not too many people have scanners and faxes in their homes. So this is sort of an impossibility for many people. So right out of the gate, we were getting questions. Well, we can't fax it or scan it, can't get to a post office to mail it. Is it okay if the notary just signs a facsimile? And what we were saying is, no, this is the only legal authorization to do this in New York. The provisions have to be strictly followed. So as a result, we saw very, very few remote notarizations. The other concern that we had was, how do you record these documents once they're signed and notarized in this unusual fashion? So we polled a lot of the county clerks around New York State, the city register in New York, said, will this be acceptable for recording? And the best response we got was from the city register of New York. That office just said, look, if the notary signs a certificate of conformity telling what they did with respect to that document, we will accept that for recording. Now, you would call other county clerks, go up the Hudson River and the northern New York area, western New York area. The responses we got from many county clerks were, huh? So that's a big concern for us in the title business when you have a document that's executed in some fashion and we're not able to record it. It means you can't complete a closing. So we had real concerns about this. So we didn't see this being used very much, and you know, it expired last June. Although last week on a commercial closing, one of our offices got in a big package of closing documents, and every one of them had on the acknowledgement, these documents are executed in accordance with the provisions of Executive Order 202.7. And when our underwriter called the lawyer and said, you know that expired last June, didn't you? Didn't you know that? He said, no. So you have to do it all over again. Well, isn't there some way that you can accept these? He said, no, these are invalid acknowledgments. We can't accept these documents. So you have compliance issues with regard to the law and the practical issues of how do you actually complete a closing. Now, one of the things is if you have an invalid acknowledgement on a mortgage, for example, it's capable of being set aside as being void because it's not properly acknowledged. It's not in accordance with the real property law. So, you know, that's something that, you know, stirs fear into the heart of any title company, total failure of title. You know, this is not just a simple form that can be redone. You're talking about a security interest that's not properly perfected. We could be exposing ourselves to huge losses. So we're really concerned with the process of these remote notarizations and the effect that might have on the validity of deeds and mortgages. So under this law, which was passed December of last year and then amended in January, there are two types of remote notarizations. The first one they call RIN, and the emphasis is on the word ink. This is where a document is sent to a signer, and the signer signs it in a pen, as he or she typically would do in the face-to-face setting, and then that document is transmitted back to the notary. And the other one is remote online notarization, where we're not dealing with a paper document at all. This is an electronic facsimile of a document that's seen on a screen, and the document is reviewed by the signer and then signed electronically. So there's no real signature. This is a signature that somehow is signed by whatever system is being used to effectuate this signing and acknowledgement process. So there are just the two kinds. Now, the first one, remote ink notarization, is just going to be in place for a very short period of time. and what happened when the law was first passed, it only addressed remote online notarization, the purely electronic form of acknowledgement. And after that law was passed, some people realized, well, we're not ready for this yet. We need to have a stopgap measure to allow us to accommodate the remote signings of documents until certain things are in place to allow us to do a full electronic signature and closing. So they put into place this remote ink notarization where the physical document is in the hands of the signer. It's reviewed online. The signer signs the document, transmits it back to the notary. But this process is only going to be available until the end of January of next year. So with the purely remote electronic closings, there's a question: can we do this now? Can we do the electronic closing now? And some people think you can, because the provisions of the law. Jason, no? I hate technology. I'm still scratching on papyrus with a quill pen, so I just. So you don't want me doing a remote online notarization. It is not going to happen.
We can't do this, but a lot.
Back one. So, while Jason's figuring this out, some people think that since the statute provides that any notary can conduct an electronic closing, that you can do either the ink closings now or the purely electronic closings. So the problem is that the statute puts in certain requirements with regard to the remote notarization that are not in place yet. First of all, the statute provides that in order to do an electronic notarization, the notary has to apply to the Department of State, and that application process will demonstrate that the notary is capable of conducting this online notarization process. The other thing, too, is, as you might guess, we're dealing with the state of New York. There will be a fee attached to that, too. So the notary will have to pay a fee. And then the statute also provides that the Department of State will devise will have regulations that will govern this electronic process. And there are no regulations in place yet. So our company's opinion, is that you cannot do a purely electronic remote notarization just yet. You can just use the ink process. And this is the provision of the statute. An electronic notarial act utilizing communication technology shall meet the standards which have been approved through regulation by the Secretary of State. And there aren't any regulations yet.
Just 2 buttons.
Good. Can you move it ahead, Jason? One slide. So this all makes life easy. We no longer have to leave our offices. We don't have to get in front of these pesky clients. We can just do this remotely. But we can't do it because the statute imposes a number of different requirements that every notary has to comply with in order to make one of these notarizations valid. So statute provides for where the notary can be, where the principal can be, the special licensing of a notary and fees, what technology can be used and cannot be used, how the notary identifies the signer or the principal, and then there are various record-keeping requirements. So the notary has to be physically located within New York State. And that's pretty typical, you know, that's the current law for a notary. We can't wander over to Connecticut and take somebody's acknowledgement in Connecticut. We have to be in New York. There are some provisions in the law in New York involving commissioners of deeds. Somebody in a city might be a commissioner of deeds, and that party can take an acknowledgement, but only within the bounds of that city. So if you're in the city of Buffalo, you can't go to the town of Amherst and take someone's acknowledgement. It has to be in the city of Buffalo. So the notary can't wander outside the bounds of the state of New York to take an acknowledgement. The principle can be almost anywhere. I was talking to Joe Petrillo earlier today, and they have a situation where somebody is shanghaied in Shanghai. You just can't leave. How do we go about taking an acknowledgement of somebody who's in Shanghai? Well, effective February 1st of next year, you will be able to do that, to take an electronic acknowledgement of somebody who's in Shanghai. When the law was first passed, one of my colleagues quipped, it was right around the time that William Shatner went up in Elon Musk's space shuttle. And he said, well, did you know that he acknowledged papers for his refi while he was up in space? And you can be almost anywhere. So this can be a real convenience in situations where you can't get somebody to come back to New York. Now, you know, we just sometimes say, look, you have a valuable real estate transaction in New York. Can't you make it a point of being here? You know? And, but people want things for their own convenience. So the inconvenience of one, the inconvenience of many. So anyway, they really can be done anywhere. And this really is a benefit if somebody is stuck in another country, if you can't get to an embassy, if you're in a country that's not a signatory to the Geneva Convention, so there's no way to get an acknowledgement in another country. So it can be a benefit. So in terms of the requirements, like, are there any requirements for a notary? So if you're just a notary, you or your legal assistants or your secretaries or notaries, you're going to need any kind of special licensing to do this? Well, for the ink notarizations you're doing now, no, there are no further requirements. But for the online notarization, the statute provides that notary shall register the capability to notarize electronically with the Secretary of State on a form prescribed by the Secretary. No form has been devised yet. And upon payment of a fee, which shall be set by regulation. We don't have regulations yet. So we're dealing with New York, so there has to be a fee. So what can a notary charge? Well, right now, that's $2 per acknowledgement or proof of signing. And if you really want to get into the notary business, now's the time, because the fee's going up to $5. So you can dispense with your senior coffee at McDonald's and now get a Starbucks. So there's an open question. What can you charge? I was talking to one title agent who set up with a company. There are some companies that do these things, national companies. And the company was Pavaso. I said, well, how do you do this? And he said, well, we had to get set up through Pavaso to use their electronic platform. We got 3 or 4 notaries in our office to get approved through this platform. Paid a $2,500 fee to do that. So if you wanted to go out doing that, you may have to sign up with a company and pay that fee. And I said, well, what are you charging? And he said, well, once we get set up on the Pavaso platform, it's only like between $20 and $50 per acknowledgement, which exceeds the New York fee. But you would think that because of the costs that you've had to incur to even get on the platform, is it reasonable that a customer using the service would have to, pay a fee to reimburse you for what you've laid out? And not only that, the time that you spend in doing it. But there are no regulations. I mean, there doesn't seem to be any provision to, impose reasonable charges for time and expense to go about doing these things. So we don't know if you're going to be running afoul of the law if you charge something extra. So I said, well, what do you charge? And the agent said, I told the attorney to flip the notary $100 for his services. I said, is that authorized not? And he said, I don't know. It just seemed reasonable. So technology. Technology must be used that allows for real-time direct interaction. Why do you say real-time? Is it fake time? Fake-time interaction? Direct interaction, containing both audio and video between the notary and the principal. Now, this is what the executive order provided. Just be able to communicate actively between the signer and the notary. Statute further goes on that the technology must allow for the recording of the notarial act, both audio and video, and the recording must be retained by the notary for at least 10 years. So some of these national companies, they do have provisions for storage of documentation. Now, we don't know if that company is going to go bankrupt next year. You know, what happens to all those storage records? But I know probably very close to 100% of the notaries in New York State, licensed notaries, don't have the capability for any kind of storage. Now, under the executive order, there was no provision with regard to recording. I think the governor and the staff, they were dealing with an emergency situation where a lot of stuff was just coming to a screeching halt because nobody could get out and move around. So they didn't really think this thing through a whole lot. I don't think they had time really to do it. But now you have this requirement of recording. So you can't do this at home. You know, don't try this at home. You need some capability for recording these documentations. Now this requirement applies to both documents remotely signed in ink, where you have a physical copy of the document being signed by pen by the signer, sent back to the notary for acknowledgement, and then the purely electronic closing. So they all have to be recorded in some repository somewhere for at least 10 years. What did I do, Jason? Security. Must the notary use technology that is secure? We hope so. When remote notarizations first started being passed into law, I think the first one was Virginia about 10 years ago. Our company was looking at these things. And they said, you know, we're really concerned about the security thing here. We're dealing with documents involving that are backstopping hundreds and hundreds of thousands of dollars of assets. And can somebody insinuate him or herself into this process and steal the documents, co-opt the documents, alter the documents in some way? And so they're really concerned about not only secure platforms, but what companies are being used. There are dozens of companies out there that purport to conduct these electronic closings in a secure manner. And our company, which has been vetting these things for years, has only approved 6 companies. In fact, we had 7, but then they recently canceled one. They said, we just don't like their platform. It's just not secure. And I know, Tyler talked about security in recorded documents. It's a concern in this area as well. And we see more and more that a lot of these frauds, they're just not one-off. They're concerted efforts to steal property, documentation, mortgage money. And, organized crime is involved, not only domestically, but in foreign countries, such as some of the Eastern European countries and Russia. In fact, some of these ventures appear to be sponsored by the governments. And the reason it's becoming a growth industry is if you're going to get involved in making money from an illegal act, financial fraud is much safer than like drug dealing. I mean, you don't do heavy time. No one's going to kill you for an incursion into their turf. I mean, it's clean and simple. So if you're caught for stealing a few $1 million, you're probably going to get probation. You're not going to go to jail. So what's the big deal? So we have more and more people getting into this this growth industry of real estate fraud. So again, we talk about Secretary of State promulgating regulations, minimum standards relating to reasonable security, and so forth. So this is all very much in the works. So, you know, one of my competitors sent out a memo, and I was kind of chuckling at it because it said, "We're pleased to announce that the legislator has passed the statute." And I'm thinking, it's all so in flux. Why are you pleased about this? I'm confused as hell, you know. So can I use Zoom, FaceTime, GoToMeeting, WebEx, etc.? Well, right now, no, because those platforms, I know they're working on it, they're developing. They don't have a secure platform, most of them. They don't have the recording and storage capacity that is required by the statute. So, you know, like I said, don't try this at home, because the way that you might personally be able to accomplish this does not comply with the statute. Now, I remember when the executive order first passed, and there were similar executive orders all over the country, in states that did not have existing remote notarization statutes. And we had a lot of conversations with our home office, and they were really trying to scramble to get up to speed on this stuff. So they said, well, you know, you can't use FaceTime. You can't use Zoom. You have to use Zoom Plus. You can't use GoToMeeting. You had to use GoToMeeting Enhanced, which had certain levels of security in addition to the basic. But there were concerns about where all this was going. So unless these platforms do develop mechanisms to comply with the statutory requirements in terms of security, recording, preservation of the record, you just can't use these platforms. So we're remote. We're not in front of the notary now. How does the notary identify the principal? Number one, the notary's personal knowledge of the principal. Now, in the course of your practices, maybe you've met your clients before, maybe not. If I list my house, say I'm in Florida, I'm sitting on my lanai in Boca. I decide I'm not leaving here. I love it here. I'm sick of New York. You know, aside from the state income tax, et cetera, I don't want to be here. Call my brother. I said, get my house on the market. Find a realtor, get my house on the market. So the realtor calls me, sends me a contract by some electronic means. You've seen these, DocuSign. Have you dealt with DocuSign? You send me the contract, send me some writers. I get an electronic signature. I sign those documents, send them back. So the realtor says, do you have a lawyer? I said, no. So I'll get you one. So realtor refers me to one of you. Never met me before. Have a few phone conversations. And now we're getting ready for the closing. You send me deed, TP 584, RP forms, some other things, some phony baloney affidavits that I'm going to sign. No problems with this property ever. Property Condition Disclosure Act. So now we're going to do this notarization. And you don't know me, never met me before, so you really can't identify me. And this is by and large what the situation is with many people signing real estate documents. Notary has never met this person before. So number one, personal knowledge of the principal by and large goes out the window. So now we have to go to the next step. How am I going to be identified by the notary? Principal presents a credential, generally speaking, a driver's license, a passport, something that's government issued, that verifies his or her identity. For example, government issued documents such as a passport or license. And the notary, using appropriate technologies, the words in the statute, proves the identity of the principal, and the credential that is presented is subjected to credential analysis to verify its validity. Now, identifying who I am, it's a question and answer thing. So if you think you have any secrets, forget about it. These companies that process this identity proofing, they'll ask you some basic questions about where you live, where you work, social security number, and they'll use various programs and algorithms to sort through amazing numbers of documents to identify who you are. And then they'll present some question and answers to you. You know, do you ever live in Larchmont? You know where Prospect Avenue is? I don't know. You shop at Cross County Center. I mean, these questions, sometimes you look at them, they're off the wall, but they're to the point about who you are. It's like, how do they know that about me? But that's what they do. They sift through millions of records to come up with some identifiers so they can prove who you are. Then in terms of credential analysis, you know, you hold up your driver's license, front, back, your passport. And again, processing these things, identifying the picture of you on your driver's license to any time your face has appeared online, you know, FaceTime, LinkedIn, et cetera, et cetera. All the markers for identifying whether or not this is a valid driver's license or a forgery. Now, under the executive order, what did you do? You'd hold up your driver's license to some crummy webcam and then flip it over, and the notary would nod and say, yeah, I think that's okay. That just doesn't cut the mustard. There's no security to it. There's no way to verify the correctness or truth or the validity of that license. So now with these identity proofing and credential analysis processes that these electronic platform companies have, they'll identify who you are before you can go about executing that document. Now the third way, so either personally known, credential analysis, or proofing, this third provision is scary. Don't even try to do this. This is where, by oath or affirmation of a credible witness, so say Tyler is going to sign a mortgage. I present that mortgage to Tyler. He signs it. I then take that document to a notary, and I swear that I saw Tyler execute that document. And now the process will identity proof me and analyze my credentials, but they won't do anything with regard to him. I'm supposedly a credible witness of Tyler's executing that mortgage. So now we're dealing with a remote situation, which is a step away from reality, and now I'm another step away because Tyler is not even coming in front of the notary to execute that document. This is permitted under present law of New York. I don't know if any of you have ever seen a subscribing witness acknowledgement. I think I saw two in my career. One of them involved a claim where an upstate New York contracting company would go and they'd sell roof, windows, front porch, siding, and they'd enter into an installment sale agreement with the homeowner. And they said, well, if you want to pay this over time, we'd like you to sign this mortgage, which will disclose an interest rate, course of payment, and then what the contractor would do, the contractor would have an arrangement with the bank who would buy that paper. So the bank would buy the contract, pay the contractor the money, so the contractor gets his money up front, and then the homeowner would make the payments over time. So in this particular situation, we hopped over a mortgage. In the course of a refinance, we hopped over a mortgage. And now that mortgage holder, there was a default, this mortgage holder started a foreclosure action, and I looked at this. I happened to know the contractor, I knew of the contractor, and I looked at the document, and I saw that the homeowner had signed it on a certain day, and then the contractor signed this subscribing witness acknowledgement. Now we're dealing with Monroe County, which is way upstate, up in snow country. And I looked at the acknowledgement. The acknowledgement was taken in Suffolk County. And I knew this contractor couldn't get out of Monroe County without a guide. And so we put in an answer and said, this was an invalidly executed document. The mortgage is void. So we got summary judgment on that case because the court found that it was an invalid acknowledgement. The document is void. And if we're dealing with a subscribing witness situation, we look at the process is, he lied and I swore to it. It's just too risky, so we won't accept that. So when we're talking about these, this acknowledgement process, the thing that we really have to look at is how valid is this document? How is it going to stand up in court in the event there's litigation? A couple of different articles talk about the concerns of remote notarizations, and they talk about the risk of litigation and the fact that the statute is so new that we don't have a track record of of how these courts are going to rule on these notarizations. So right now in New York, a notary doesn't have to do anything with regard to a document in terms of taking an acknowledgement, sign your name, put your stamp on it, everybody goes on their merry way. The statute now imposes a duty on the notary to keep a journal. And what this journal has to do has to be made contemporaneously with the act. So you start making your entries right at the time somebody signs a document and you acknowledge it. Indicate the date and approximate time of the act, the name of the principal, the technology used to perform the remote notarization, indicate the number and type of notarial services provided, and indicate the type of credential used to identify the principal. So you have to make these log entries. And the notary has to keep this for as long as such notary public remains in office, and then for an additional 5 years thereafter. So I've heard that notaries retire sometimes. They change careers. They die. What happens to these records? I mean, these requirements are in place so that we have the ability, if this acknowledgement is challenged, to go back and come up with the proof that it was validly done in accordance with the statute. And if somebody's gone, they're gone. We're lacking that proof. And then the big thing, how do we get them recorded? This is a major concern. And the one thing I would just ask and caution you that if at any part of the transaction you're going to be presenting a document that has been remotely acknowledged, please contact the title company involved so that they can vet it with the particular county clerk to verify that, number one, we're going to accept this remote notarization as being valid. It's done properly by a recognized company. And number two, will the county clerk take it? You're dealing with a sale of $1 million home or a $2 million home. You can't get the deed on record. It's a real problem for us. In fact, if we can't get the documents recorded, you don't even have to worry about Tyler's issue anymore because no one can steal something from you that you don't even have. So in order to record the acknowledgement should say somewhere words to the effect that this remote notarial act involved the use of communication technology. It doesn't say a whole lot. So then in addition to this, we talk about remote ink, so where you're dealing with a real document that's going to be recorded in some fashion. In remote online, you're dealing with a purely electronic document. None of the recorders in New York have the capability to accept an electronically acknowledged document. So you have this process of papering out. So if you have the ink document, you have it printed out, you have the original, probably going to send it to a couple of companies, Simplifile, can't remember the name of the other company that we use frequently. They really deal with this e-recording. But attached to this remotely acknowledged document is the certificate of authenticity, whereby the notary is saying, I did this. I conducted this remote electronic notarial act, and this is a valid document. So what happens if the notarization is not done correctly in accordance with the statute? Is it void? Is it voidable? We just don't know. You know, we just don't know because it hasn't been tested. One thing that we're concerned about is litigation factor and challenges to a document. What we're seeing now is a lot of litigation involving mortgages, where somebody defaults in a mortgage, a foreclosure is started, and there are dozens and dozens of requirements to validly conduct a mortgage foreclosure. And somebody's going to lose his home. You'd be amazed at the affirmative defenses that we see by a defaulting borrower about why this mortgage is invalid. They go through the whole list of the requirements and saying the lender didn't do that, they didn't do this, they didn't have standing, they don't have standing to sue. And you end up with people who may, while this litigation is running its course, may be living in a home for free for like 10 years while this litigation is going on, with this confusion over these particular affirmative defenses, where you may have a lender who was not involved in the original closing. There might be the third assignee, the fourth assignee, and they're scrambling to try to come up with adequate proof to identify what happened with that mortgage from the time it was executed through the time the foreclosure was commenced. These things go on for years and years. We anticipate similar defenses being raised with regard to electronic notarizations. The requirements of the statute are just so opaque, very hard to follow, very hard to document, that we anticipate that we're going to be seeing some failures of title just because we just don't have enough proof to stand up to the remote notarization, to prove what we insured is what it comes down to. So the bottom line is most notaries can't do this on their own. Any notary performing remote notarizations will have to work with a company that has the technological setup to comply with the statute. And there will no doubt be costs associated with remote notarizations that are not present within person notarizations. Now, I guess the service charges, I mentioned that a little bit before. We just don't know if the state is even going to opine on what might be appropriate charges for these things. They can be time intensive. You have to set the whole thing up. It could take several hours to do that. And then to deal with the log issues, to deal with the data storage issues, all these things take time. And I'm sure that they're, with time they'll become a little bit more streamlined. But at the moment, we just really don't know how it works. Now, how frequent are these? You read articles and they just talk about how great this is. I talked to one of our divisions. How are you doing that? It's a company called ServiceLink. They operate a lot in the default services area and also in the mortgage refinance area. They work with a lot of major banks on major refinance accounts. They deal with thousands and thousands of these transactions a month. A lot of them might be home equity lines of credit, where some lenders don't even want title insurance on these transactions unless the mortgage exceeds $750,000. But they process lots of these transactions. And when Ron was first passed, I talked to two of their senior counsel just to get their experience. They're nationwide. They operate in every state and several U.S. territories. And I said, what is your experience with this? Because you're dealing with 25, 30 states that have RON statutes. And the one gentleman said, he said, when the pandemic first hit, they asked me to do some research and investigation about this. And he said, I did a ton of research, a lot of investigation, many of which, much of which never made it to the light of day. He said, in some ways it was a wasted exercise. I became an expert in the field that nobody seems to care about. But I said, well, what is your experience ongoing? He said, well, when the pressure was off once the pandemic somewhat lifted, but he said in the last 2 years, he said, I think we were involved in between 300 and 400 remote notarizations across our entire geographic footprint. So that means in the course of a year, 150 to 200 deals. And I just said, well, why is that? And he said, well, despite the fact that Fannie Mae and Freddie Mac, two major mortgage insurers, despite the fact that they are on board with the online notarization process, they look at it as a real streamlining of the mortgage closing process. So most of the banks, the major banks, don't want anything to do with it. So when we had the executive order came out in New York, you'd have a bank like Wells Fargo. They just said, no way, we're just not doing that. We're just not doing that. And I think part of the concern is that you have different states, different laws, variations. They want uniformity. They just don't want convenience and streamlining. They want uniformity. And when you have different states that have different requirements, it's a real problem for them. So I really think that we're not going to be seeing a whole lot of this in New York until the lenders get on board. We're still going to have situations where there's a desperate need, like the people in Shanghai, people in Eastern Europe, people in Africa, people traveling where they just can't be here. And we will have to, suck up and deal with this stuff. And I think we'll be able to do that. But it's not really going to be a wave. And I do think that the thing to remember, it is not necessarily a convenient, easy thing. There's some setup that's required. And if you have a transaction where you know it's going to be an issue, you have to prepare for it in advance by getting your title people on board with it, so they can help expedite the process. Finally, the statute provides that any person who suffers damages as a result of a principal who violates any of the provisions of this section. So you have some fraudster who's executing some documents, and as a result, we suffer a loss. So we don't find a whole lot of comfort in that. I talk of one area of the law. You have an open title issue, and we'll get an indemnity. We'll just get an indemnity on that. Well, you know what the definition of an indemnity is: chasing rights. So an indemnity without a cash deposit is essentially worthless. The same, if somebody commits a fraud, does it help us that the statute provides we can chase them for damages? We can do that anyway. Just good luck with that. It's just not going to happen. Does anyone have any questions? You're all enthusiastic about doing remote notarizations, I know.
How do you tie in the costs on a disclosure statement that you have to provide to the bank?
The question was, how do you tie in the cost on the disclosure statement that you provide to the bank? I don't know.
Which says it can't change.
Yeah, which says it can't change. Yeah, the statement says it can't change. I don't know. I just don't know.
So I know that you're active with the State Bar, and I know that the Land Title Association is active. Are they in discussions with the Secretary of State on the regulations, and is there any indication of the timing of those that we might see?
There were some approaches to the Secretary of State, and their answer was, hold on a bit, we'll get back to you.
Okay.
We'll get back to you. There's been a lot said about the notarization in New York. And, unfortunately, just about every writing talks about what the requirements of the law is. Not very much is said about how do we do this. How do we do this? So we're all pretty much in a holding pattern here until we're not going to see very much in the RIN area for the next few months. And then come the end of January, anything goes. We're still waiting for a lot of things for the government to do a lot of things to allow us to do these right.
Thank you. We also have a question that came in from online that I'll run through, and it really has to do with the whole storage issue. And I personally foresee that as one of the biggest issues with doing this, because I understand that the size of the recording is substantial in terms of storage space on a computer data, and I think that that's going to be a substantial impediment to maintaining these for a long period of time. So the question that came in online is, has the penalty been identified for failure to keep the records for the 10-year period?
It's all up for grabs at this point in time. Nothing has been articulated in terms of compliance for failure to comply.
I wonder if that can even be something that can be done regulatorily if it's not in the statute in terms of a penalty.
I think the statute leaves open a whole lot of questions that have yet to be resolved, and I think we're just waiting for the state to respond. I don't think the state, even when the statute was passed, I don't even think they really thought through all the requirements of the statute and really what is going to be necessary in order to comply with all of the statutory requirements. And our storage is huge. I know our company is a big company, many employees, and they're for years have been just struggling with storage capacity with regard to email, for example. And I get these videos from my children, and they just freeze up my phone. And so it's almost like storing a mini movie for every notarial act. And if you have a complicated transaction with multiple documents, it just could be enormous. So I just don't know what's going to be done.
It was a much simpler process under the executive orders. And I know that we did quite a bit of it for people that just couldn't get to a closing. And I have to admit, I'm not sure I ever asked them to turn over their driver's license to see the other side. But one of the questions that I had was this journal that has to be maintained. Is there any indication of, does it have to be in hard copy, or can that be electronic as well? Or is that something we're going to have to wait for the regulations on?
Wait for it. And there's a journal requirement in many states. They require notaries to maintain journals of their notarial acts. But this is a little different because there's the enhanced requirements for the electronic notarizations. There's a lot more information that has to be put into that journal. So, and in terms of record preservation, how's that done? How do you keep track of it? Thousands and thousands of notaries. There's really no way to track it. So, and I think there are so many different requirements. It's easy to poke holes in an acknowledgement by just raising some questions about the full conduct of the Notarial Act. So I think we're going to, and look, I'm not just going to say we're going to have a tsunami of claims. There's no, I don't think that's going to be the case, because in most cases, people are essentially honest, or I could say people are essentially honest. These transactions are regular, or there's a big chunk of the population. It's not necessarily that we're necessarily honest. We just don't want to suffer the consequences of being caught for doing something wrong. But there's that small segment of people out there who will take advantage if they have to or if they want to, and those are the things that are concerned. Like if we suffer a total failure of title on one residential mortgage, I mean, that could be our revenue on 1,500 or 2,000 policies that we've issued. So just a few handfuls of these things can be financially devastating. So those are our concerns.
Is there, if that closes out our questions from the audience, I think we can move on to the release of the final code for the online folks.
There might be a slide somewhere. I don't. It's covered risk. Jason? And I apologize for dancing you around on the slides. I'm not a tech guy. Covered risk is the second code.
Okay.
John?
Thank you very much, Frank. I want to thank Frank and Tyler for the presentation this morning. It was very informative, and we do have some other questions that came in from the online participants, and we'll get some answers out to them later. I want to thank everyone who came out here today in person and those folks online for joining us today. We'll hope to continue this type of format for as long as it makes sense. I do have to note that for CLE credit, if you're here with us in person, please complete the attendance verification form. And those online, both codes announced during the webinar are necessary to receive your credits. If anyone wants an additional copy of the materials, they're available on our website, or just reach out to any of us. So again, thanks everyone for coming out this morning and joining us here at Westchester Hills.